Hear ye, hear ye. I will Chief Justice and Justice of the Supreme Court of the State of Michigan. All persons attending business with this honorable court are admonished to draw nigh and give attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Welcome to the afternoon session. Apologize for taking the bench later than I indicated, but we are ready to go. And first case is Department of Health and Human Services versus children. What are your clients?
The Hicks Brown children.
Hicks Brown, thank you. Somebody's going to pay for not having it on my sheet here. Okay, thank you. Sorry.
Good afternoon, Your Honors. My name is Bill Ladd from the Michigan Children's Law Center, and I'm the lawyer guardian ad litem for Destiny Hicks and Elijah Brown. Also appearing on behalf of the appellants are Eric Restucia and Leslie Farrow from the Attorney General's office. We will be sharing the arguments here. I will be taking 10 minutes for my argument.
You have to manage your own time.
Okay. And I also reserve 2 minutes for rebuttal. Thank you, Your Honor. And first of all, I'm asking on behalf of the children that this court reverse the decision of the Court of Appeals and reinstate the trial court's order which terminated the parental rights of the respondent mother. In doing so, I would ask that this court reaffirm the Court of Appeals decision in Ray Terry, particularly where it required a timely claim by a respondent parent of an alleged violation of the Americans with Disabilities Act, and that claim had to be close in time to the adoption of the case service plan, and failure to do so, as here, should result in the waiver of such a claim. The primary consideration in any child protective proceeding should always be the safety and well-being of the children who are the subjects of the case. And it is through this prism that the courts, whether it's the trial court, the Court of Appeals, or this court, should consider the obligations of both the agency and the parent respondent. When considering the issues here, this court must keep in mind that there was overwhelming evidence to support termination of the respondent mother's parental rights, and that she's never challenged the sufficiency of the evidence on appeal, either in the Court of Appeals or here in this court. This court should also keep in mind that the case began because the mother said she could not care for the children.
Counsel, how do you address the fact that almost immediately the workers working with the mother were aware of her impairment, her emotional or mental impairment?
Well, again, Your Honors, and as the court states it, the workers were aware that the mother had some limitations. That alone is not enough to trigger the requirements of the ADA.
So your position is somebody who has an IQ roughly of 90 and some difficulties that come from that has to be competent enough to say, I have a disability, it's an ADA disability, and you need to accommodate me. That's what's required?
No, that's not true in all of these cases.
No, I'm just saying, I'm trying to understand what is required to trigger the obligation of the department in its statutory obligation to reasonably accommodate this mother if they are aware that she has emotional or mental disabilities.
Well, again, first of all, I think it has to be raised specifically in the trial court. Again, all respondents...
I'm talking about the statutory obligation now. They very early, at least as I read the record, understood that she had significant impairments. They wrote it down, and there are lots of different points along the way. I don't think anybody failed to appreciate that this woman had some kind of disability that impeded her ability to function. Do you dispute that?
Yes, no, I don't dispute that. The thing is...
Okay, so let's stop there.
Okay.
If the workers are aware of the disability, doesn't a statutory responsibility to create a plan that is specific to the mother for rehabilitation, for reunification purpose, don't they have some obligation to take that into consideration?
Well, I think that was taken into consideration. What the court should note is that this case took approximately 11 months to be adjudicated, and the case service plan was adopted approximately a year after the case actually came into the court, which was right after the adjudication as related to destiny. And the services that the agency was required to provide did not attach until that point in the case. The way that the agency provided the services required by the court were that they were took into consideration the mother's limitations. I should note also that during that period of time...
Counsel, you said they took into consideration the mother's limitations, but the question I have is they asked her, they made part of the requirement that she get a GED, and then they were also cognizant of the fact that she couldn't fill out basic forms. So how did they kind of accommodate her based on that? If they say you should get a GED as a requirement, and then at the same time they're aware of the fact of her limitations, doesn't that show a little bit of a disconnect?
Well, again, throughout the time that the mother was being asked to fill out various applications, she was assisted with that. And
at that point, counsel, shouldn't they then have been aware, based on the standard, as to the fact that this was an individual with a disability that had a cognitive impairment?
Well, what happened was is that the agency was providing the mother with assistance to apply for an SSI, which was unsuccessful. The agency then provided...
Right, but at that point, isn't that when the accommodation issues should have kicked in, at the point they were aware of the fact, or should have been aware of the fact, that she had a cognitive impairment?
Well, again, first of all, I don't believe that that's the operative point when the requirements of the ADA kick in. And for answer the situation here, what's happening is this is a question of reasonable efforts. The reasonable efforts requirement as to the family kicked in again approximately a year after the case came into court as in terms of services provided to the mother.
That was after the service plan, though, right? This came in after the service plan.
The service plan was not required until after the disposition. What's particularly telling here is that if there was to be some requirement of the agency providing assistance to the mother before the original disposition, the mother was simply not available. She was not visiting with her child until right before the initial adjudication. And it was at that point that the agency began to provide services to the mother. What happened then was is that as difficulties developed with the mother's ability to cooperate with those services, the agency attempted to make adjustments.
But then that brings up the next question is, what do you do with someone who has a cognitive disability who isn't aware of the fact they have a disability? How do we approach that in terms of when accommodations should and have to be made? Not all disabled people identify. So how do you work through that when sometimes when you're dealing with psychological disabilities or cognitive impairments one of the challenges of the disability is the failure to admit to the disability. And if you can't admit to the disability, then you don't provide this, you don't ask for the services. So how do we approach that?
Well, essentially, the approach to that is what was done here is that the agency provided evaluations of the mother and the court. And then the court acted on those recommendations from, first of all, the court's clinic for child study, and then the psychological and psychiatric evaluation.
And then the department didn't follow those recommendations that issued from the evaluations, right? They didn't implement a plan based on the recommendations of the psychiatrists or psychologists, did they?
Well, they did to a great extent, yes. They provided parenting classes, they provided individual therapy, they provided a parent partner, they provided her with assistance in applying for SSI assistance in
Let me ask
attempts
a question. Did the trial judge, in determining termination was in the best interest of the children, make any assessment of whether the plan and the services applied to the mother were sufficient to help her quest to be reunited?
The trial court throughout the case made determinations that the services were appropriate for her needs, at every determination of whether or not reasonable efforts had been made. And what happened with the reasonable efforts is that when the court in 2014 adopted a plan that required the agency to file a termination petition, then the reasonable efforts were to accomplish that permanent plan. Despite that, the agency continued to make efforts to reunite the family by providing services to the mother. You have 4
minutes left.
Pardon?
You have 4 minutes
Oh,
left.
thank you. And so in total, okay, at this time, I would then defer to co-counsel.
Good thing you speak fast.
May it please the Court. Eric Ostucha from the Attorney General's Office on behalf of the Department of Health and Human Services. I want to begin with a caveat, which is the Department recognizes that parents with limited abilities can serve as good parents and that they have the same rights as everyone else. But to zero in on the question that was being asked about preservation, I think there's a distinction between bringing a claim under the American Disabilities Act and one that you require reasonable services and require specialized services. The narrative of this case, before it got to appeal, was that she had an emotional problem, not that the primary problem wasn't one of limited cognitive ability. So if you look at the psychological report and the psychiatric evaluation, they both zero in on emotional distress. And she was given individual therapy. The services that were provided tracked exactly the kinds of things that were in Dr. Lino's psychiatric report and in the Dr. Long's psychiatric evaluation. So you had individualized services. Those services were the parent, a peer, 2 different parent peers that provided services. She had individual therapy from a licensed counselor. She also received medical services or mental health services from the Northeast Guidance Center. Now, in August of 2014, she said, I don't want mental health services. I now want for people with developmental disabilities, I want services for parenting skills, to develop my parenting skills. The Northeast Guidance Center was already providing mental health services, and so she had to be transferred from the mental health services to the...
Okay, I understand. Let me ask a more architectural legal question. What is the rule, assuming that we take some action, that should issue from this court? What rules concerning reasonable plans, ADA, notice, et cetera?
The Terry case, I think, outlines it well. The Terry case is a 2001 Michigan Court of Appeals case. The mistakes from the Court of Appeals here is that there is an independent obligation of the department to identify and to provide services that are individualized. I think that's right. Okay. But I think there's also a corresponding obligation on behalf of the parent and really the parent's attorney to identify those services that are necessary. The attorney here only was 18 months into the service plan before requested this developmentally disabled plan through Northeast Services. That's very late. In fact, 15 months is kind of kind of the gold standard. The second thing is it can't be that there's only one reasonable approach. I think that the standard here suggests that unless you went to the Northeast Guidance-centered development disability plan that you hadn't received individualized services. It's untrue. The court changed the nature of the endeavor, which was one to focus on mental health. In fact, the basis of the termination was because of a lack of motivation. So it's important that the court, if it does somehow think that there's only one size...
Let's say, I'm just trying to understand the legal principles. If Terry is the principle that violation of an ADA is not a defense to the termination, but you have to timely raise it. The question is, when we're dealing with this either emotional or cognitive impairment, it's hard to imagine somebody being able to understand, either because they understand what their illness is or what service is available. Are you familiar with Robertson versus Los Anima?
What was the name of the case? I'm sorry, Your Honor.
Maybe I'm not. Los Animas.
I am not.
Well, it's a 10th Circuit case that says actual awareness of the disability obviates the obligation to make a formal ADA demand.
Oh, I think it right that if you take this, the ADA doesn't provide an independent basis. So really what the department has an obligation, once aware, to create a plan that's reasonably tailored to enable the parent to be reunified with the child. I think that's right. I think, though, it's important that this court articulate that there's a corresponding obligation on behalf of the parent, not because I think the parent's going to be able to do it, but the parent has an attorney who has information, more information sometimes than the department does about the needs of that parent. Here, the parent had been receiving individual therapy throughout and was receiving some mental health services through Northeast Guidance Center and then asked to change the nature. My thought is 18 months in, that's late. Now, the question of whether the services up to that point have been adequate, I think that they were comparable to the things that have been requested by the psychiatrist and the medical doctor. But if not, I think at the end, this court should still reaffirm the idea that the parent has to benefit and respond.
Mr. Versucci, is that right? I mean, does that practically reflect how these cases work? I don't know enough about the trial level, but my understanding from the lawyers working on improving the bar for parents and children, frankly, is that often the agency has far more contact with the parent than the lawyer does because they're not paid very much, in some places very, very little, and so they're not. We see ineffectiveness claims on these cases all the time. They don't take the time to go to their clients' houses, and whereas the social worker is the one who actually is at the mom's house, dealing. So I just don't know how to make sense of that. It's not like a criminal defense case where I do think the lawyer knows better than the prosecutor's investigator.
It seems important to me, though, that I think it's right to say that the department has an independent obligation. It recognizes it according to its own policies, that it has this obligation once identified. But I think it would be a mistake for the court to have an opinion that reads like the Court of Appeals opinion below, which says nothing about the independent obligations. You may be right as a practical matter that, as it stands now, many of the attorneys appointed are not doing enough on behalf of their clients. But that doesn't mean that the standard shouldn't be. We have a full expectation that if someone is doing the right thing, that they are attentive to the whatever disability that their client may have, and then bring it to the attention of the court, and then ask for the services that are necessary. It seems to me that it should be a kind of mutually complementarity, because in fact here the
I like that. I mean, that makes sense to me too. I'm just trying to think. I'm just trying to play it out. So, say you have a super crappy lawyer. They exist. Who doesn't even notice that his or her client needs services for a cognitive disability, but we know the worker absolutely did notice because they spent enough time at her house and whatever. So then the petitioner's lawyer, the mom's lawyer doesn't bring this to the attention of the court. We hold the lawyer responsible. We deal with it on appeal and in an ineffective assistance of counsel claim. Everybody's worse off because now 2 more years have gone by. And
no, but I think the fact is that if it's something that is known to the agency and the agency fails to provide reasonable services, fails to make reasonable efforts, that's going to be a basis. I mean, there's language from the Rood case that's been cited by Brown that says there'll be a hole in the factual record. So that I think the importance of having it be a obligation that runs to both the department and to the attorney for the parent makes sense, but I don't think that cuts the department loose from providing reasonable services. And if there's not the provision of reasonable services, then that would be a basis on which to reverse a termination unless, and here, my thought is for this court, if you conclude that it had to be that they had to identify and provide this one particular service at a Northeast Guidance Center for those with intellectual disabilities, and it was requested, 18 months in. If that's still the case, that she had to have gotten that service in order for the services to have been reasonable, there is still a basis on which to reverse here, because the basis of the trial court's decision of the Wayne County Family Division was a lack of motivation. And there is substantial record support that she had essentially given up on the ability to be a parent in the summer of 2014 because she had suicidal ideations in January and June of 2014. And then her therapist identified this in her reports in August of 2014 that she wanted to give up on her life and her children. That's a statement from the report from the therapist. And then in February of 2015, she struggles to motivate herself to accomplish the things that she desires. She only, from May of 2014 until May of 2015, she attended 9 of 13, 5 of 12, 5 of 12, 6 of 12. She was stopping her regular visitations. So when the court here concluded that she is totally unmotivated, that was an independent basis. So even if you thought that somehow the services were inadequate, the court should still reverse because she would have not have taken advantage of that service at the point at which it was offered. Consequently, the proper disposition would be still to reverse and to reinstate the termination. Because if you look at the...
Mr. Stufer, can I just ask you one question, please? I mean, clearly to me there were some imperfections in the way that DHS handled things here. But there were at least as many imperfections in the way that the mother carried out her obligations here. You've mentioned a couple. She was uncooperative with DHS. She failed to fill out the necessary paperwork. She failed to show up for appointments. She failed to go through the job orientation. She failed to stay in contact with DHS. It took her 3 referrals before she engaged in a parenting class. She didn't show up to visit the child. Is it our obligation to look at all these acts or lack of actions on her part and try to identify which are a function of her disability and which are a function of her lack of parental character or motivation? What exactly is our task in trying to give weight to the shortcomings that she manifestly demonstrated in this process?
It seems to me that what was identified early on and what the department had tried to do was address her mental health issues or her depression. That was the view of the department was that was the primary problem, and that's ultimately what was the basis of the decision of the probate court, was that it stated that she really doesn't do much to cooperate and she's totally unmotivated. So that was the finding. So this court then is left with a factual finding, and it's subject to a clearly erroneous standard. There is then support in the record to demonstrate that she did lack motivation. It seems to me this court is bound to then see if that was a supportable decision. And if it is, the effort to take an entirely new narrative, which the Court of Appeals essentially provided a de novo review and provided a competing narrative of what happened below.
But just help me explain. I mean, looking at all these things, and I just named a few, do we attempt to attribute that to her disability, or do we attempt to attribute it to her lack of motivation? And if it's her disability and not her motivation, do we care? The fact is she's not providing the kind of guidance for her children under those circumstances, is she? I
think the question of do you care, could reasonable services have remedied that problem, and could reasonable services now remedy that problem? If the answer is yes, then you do care. And if the answer is no, then it has no bearing on the ultimate disposition. In other words, determination would be affirmed.
Provided that we should or should not care, that there are additional reasonable services. She was provided a lot of services, in my judgment. Is there any, what in your view is the strongest argument in favor of your position that there are no additional services that could have been provided that would have overcome the injuries or the damages she was doing to her children because of her disability?
The strongest argument is that she received a substantial amount of individualized services. And at a time in which she ultimately kind of developed this lack of motivation, summer of 2014, she was receiving mental health services. We know from the record that she was going to Northeast Guidance Center to receive reviews of her medication. It seems to me that if she's receiving this substantial level of services and then has become unmotivated and fails to meet with her children and do the things that are necessary for her to be made able, that the right answer is that the services have been individualized and that there's not only a single view of how the department can provide those services. And once they provided what is a reasonable level of services and she does not respond, that will be a basis on which to affirm a termination decision.
Thank you.
I'm sorry.
Is there any way to know whether these services were the typical services that come out of the toolbox for trying to set a parent on the right path, or unique services that could be identified as being provided for this?
There were, I think,
disability?
you can identify 5 services. The parenting skills, those were general, and I'm sure
Right.
Mr. Sankaran's going to identify that those are very general services.
Right?
She had a therapist who was a licensed counselor. That's individual services. They were individualized. Now, candor, did she have training in how to treat people with limited cognition? That's not on the record. But that was still an individualized service.
But it's not unusual in any other case for a parent to get the same type of
No,
service.
individual therapy, in fact, that was, if you look at Dr. Long's evaluation, his psychiatric evaluation, he has 5 recommendations, right? He says, maintain a positive attitude, more parenting classes, parent partner, community health agency. I mean, arguably, she had all those things. Individual therapy, medication, pursue a GED. This was Dr. Long's. This is the May 30th. In fact, Ms. Brown's brief takes this report and says the department totally failed it. Now, I think if you look at this report, it's attachment C, it runs 1 through 5, and you look at the 5 things that this medical doctor suggested be done, the department was pretty close to it. Now, the department could also have provided, through the Northeast Guidance Center, intellectual disabled parenting skills which were particularized for people of limited ability. It didn't do it. She requested it in August of 2014, and it never happened. It was still 18 months after this thing had started, and at the point at which the attorney asked for that service, it was where she had lost her motivation. That's where she makes the statement to her therapist, I want to give up on life and the children. So it seems to me that there are, of the 5 things, there are 4 things that are individualized. None of them, I think, relate to limited cognitive ability. One of them was clearly designed for people with mental health issues, the Northeast Guidance Center, and providing medical review regarding the medication she was taking. But we don't have information necessarily about what exactly the services that were being provided by that psychiatrist. But it was individualized and specialized for someone with a disability for mental health issues. This change, though, in the focus to limited disability came later in the case. Now, maybe the argument is the department should have known from the very beginning that she had both a mental health issue and limited ability, and that was sufficient in these recommendations to know that they were supposed to provide services. But if you review this report, it's not like the department blew it off and didn't provide individualized services. It didn't provide the exact thing that she requested very late in the game. But the answer, too, is that it wouldn't have mattered because of her total lack of motivation.
Okay, so that leads to my question, which is, it sounds like you're arguing for a harmless error standard of some sort.
That's our third argument, but yes.
And I have 2 questions. One is, have we ever done that before in these sorts of cases, employed a harmless error standard? And whatever you answer, what should that look like? Is it your burden to show that the error was not harmless, or is it their burden to show that it was? Yeah.
All right.
Or if I said that backwards, you know what I mean.
I do. This court has not said it. The Michigan Court of Appeals had said something along these lines, but not in an express way, saying the service wasn't required, but even if it had been provided, the person wouldn't have benefited from it anyway. So that's in very free. There's a case which has this kind of as a throwaway line. So it seems to me that would be a useful advance in the law to talk about it and to outline it a little more clearly about it being a standard, because the statute does provide expressly that there's no requirement for any services under certain aggravated circumstances. Now, those aggravated circumstances aren't present here, but the idea is that sometimes it doesn't matter what services you provide, the person was not going to benefit. I mean, we're very far into this proceeding insofar as the children were born in January 2012.
Nobody's made that determination.
What? I'm sorry?
No one's made the determination that she wouldn't have benefited anyway.
I think the conclusion of the trial court that says she's totally unmotivated, I think that does answer it. It seems to me that just because you have limited
Well, but maybe the
cognition.
reason you're unmotivated is because you weren't getting the right services. Like, they're treating me as if I have a mental health problem, but what I really have is a cognition problem.
But
And
she-
so nobody understands what I really need, so I'm kind of unmotivated.
And further to that, it appears there was
But I-
quite a delay at the beginning before any evaluation was done in the first place.
That's true.
Still want to
There
know,
was a delay,
though,
there's no question. Go ahead.
if we were going to give you a harmless error standard, I want to know what one you want.
Oh, and it would be, I think you're right that it is it would be the department's obligation, I think that's right, to say that you would not have benefited. I'm
By
never
what standard? Beyond a reasonable doubt, clear and convincing, preponderance?
Oh, it's a preponderance standard, yes, I think that's, I mean, these are,
If we're asking, okay.
Yeah, no, I think
We're
that-
burdened by a preponderance.
right, because, I mean, in a way, insofar as there's been a factual determination, it's the parent's burden to show by clear error that the finding was improper. So I think I would have the benefit of that fact finding, and then the question is, with that fact finding of lack of motivation, have I shown that any failure to provide reasonable services has been shown not to be outcome determinative? Because it's ultimately a determination of causation. We're going to say there was no causation, even if the services were inadequate.
Thank you.
But can you just address the point that Justice Larson raised, because I was going to ask the same question, which is what if we conclude the lack of motivation was caused by, first, the delay in providing services or evaluations, about a 9-month delay, and then thereafter not providing the type of services that this person apparently needed? What if someone gives up because they get frustrated because they're not making any
Well, I
progress
think then
because
the
you're providing
question-
wrong services?
The question, it seems to me, is if you think there were inadequate services, really the issue is, would services now make a difference? The services that she requested that she never received, if she got those now, and
that's a
would she be able to receive them now and then be the kind
That's a
of
different
parent?
point, though, than saying there was alternative grounds at the time that are enough.
No, I don't think it is, because the question is this: are we going to send this back for further proceedings to receive the services that you didn't receive previously? In fact, that's the current posture of the case, right? Right now, there's
I mean,
ongoing
I'm not an
proceedings.
expert, but you're saying that if she lacks motivation now, there's good reason to believe that even if she got the proper services, she would lack motivation in the
Well,
future?
I guess I want to resist that full characterization that she didn't get the proper services. She does have emotional problems. She had suicidal ideations in January and June of 2014, and she was receiving things that were relevant for what she
I'm not
had.
suggesting she didn't receive any services. The question is whether she received either all of the services that would be reasonable under the circumstances, or the ones sufficiently tailored to her, that's all.
Well, if you did conclude, boy, she should have gotten this additional service, and she requested, even if late, she should have gotten it, I still think it would be her duty in order to prevail on that. I mean, we're going to say we have to carry the burden, but she would still have to be able to benefit from those services now. It seems to me, because if it is, let's say we have tainted the well, that we had this opportunity, she had this window of opportunity, and we didn't provide the service, and now she's been now in a condition where she can never benefit from the service. That failure, although sad, would still not provide a basis for relief, because the question is, will she be reunified with her
I
children?
understand that. I don't know that we're making any final conclusion on that point. All I'm saying is it sort of undermines your alternative argument on lack of motivation. If we were to conclude that she didn't receive the services, first, timely, and second, services that were actually tailored to her specific disabilities.
Well, then you would ultimately be ruling that they have shown by clear error that this lack of motivation wasn't somehow a property of her character, but rather from a failure of the department to provide services. It would still be an obligation, however, for Ms. Brown to demonstrate that she could benefit from those services now.
Thank you again.
I'm sorry. Thank you, Your Honor.
He used up most of your time, so.
And everybody else.
I will be brief,
Thank you
Your
for
Honor.
having it.
May it please the
And
court.
he used 1,000 more words than anybody else could have gotten in there.
Yeah, that was the longest 4 minutes I've heard. May it please the court, Vivek Sankaran on behalf of the appellee, Shawanda Brown. I'm happy to answer any questions this court may have at any time.
I do have a question. I take it you have the belief that your client was not provided adequate services.
Correct.
The trial court nevertheless terminated because it determined that the termination was in the children's best interest. I'm wondering what you think. Well, first of all, the Court of Appeals imputed a whole lot of standards that are nowhere found in the statute. You agree with that, right? About what the department should have done but didn't?
I think there are parts of the Court of Appeals opinion where they gave examples that were not part of the statute, that they went sort of beyond
They
mandated
those.
But the framework of the Court of Appeals opinion, which is that if you don't make reasonable efforts, there isn't sufficient grounds to terminate parental rights, is taken straight from this court's jurisprudence in Inri, Root, and Mason.
I understand, but part of their calculus, it seems to me, was based on a litmus test that they made up.
Well, I would disagree, Your Honor. I think that in large part the examples given by the Court of Appeals as to what the department should have done in this case were taken from the department's own evaluators. And that to me is sort of the heart of the error in this case.
Well, counsel, I have a question then. You know, if you could help me to understand, when we look at when we read the Court of Appeals opinion, I guess my question is when you look at reasonable efforts and you're working with a person with a disability, tell me exactly, like in terms of trying to do reunification, how do you, I mean, you know, it's not, there's not all these service providers that are out there. So in a situation like this, tell me specifically kind of what service providers you can look to when you're trying to work with a case as difficult as this.
Certainly, Your Honor. So the first step is that every county in Michigan has a developmental, an agency, a mental health agency, a community mental health agency that has specific services available to help and assist individuals with developmental disabilities. That, if you look at Inri Terry, for example, the case that the department cites over and over again, that was at the core of how the Court of Appeals found in Terry that reasonable accommodations had been made. At the outset of a case, they had linked the parent to this community-based agency that provided that specific specialized type of assistance. That never happened in this case. In this case, what we have is at the outset of the case, the department observed that this parent had cognitive disabilities. I disagree with Mr. Restuccia's assessment that this is a case about emotional issues. In the department's initial service plan, one of the requirements they have is that this mother should obtain the intellectual capacity to parent.
But what happens if, I mean, I want to go back to my original question though. I really want to get a firmer understanding of this. What if there aren't programs and services that are available? I mean, these are very difficult budgetary times and, you know, there's not always programs and services available in every county. So, you know, what is it that you would like in terms of this court as we draft an opinion? You know, how far do you want the agency to have to go as it pertains to trying to do reunification? I mean, you know, what if there aren't programs and services available? Then what do we do?
I would think that so the trial court would have to make a determination about whether the lack of services sort of impacts the reasonableness of the efforts that need to be made by the department. And so, for example, if there's some sort of intensely costly service that's just not available in a community, and that the trial court has the ability, after considering options, to determine that it is reasonable for the department not to take such an extraordinary step in a case.
So then you would allow for it to be done, you would really want to make this more of a standard that's subjective to the local trial court to determine what is in fact available and what is not.
Well, I think at the threshold level, the trial court sits in the best position to make a determination about what's reasonable and what's not. This court would sit on review to determine whether that determination was clearly erroneous. But I would concede that that's a deferential standard. The trial court has to assess. It does this every day, Your Honor, in cases that don't deal with disabilities, when they're trying to assess sort of the types of services that are available to, that should be offered to parents. In this case, though, and I understand that this court is fashioning a rule broader than this case.
What's clearly erroneous about what the trial court actually did here?
The trial court found that it was reasonable for the department to ignore its own evaluators as to what this parent needed. Not one of the services that the department offered this parent was specialized in any way to deal with a parent with cognitive disabilities. In fact, it's actually telling that they created the service plan before they had any evaluations of this parent, and then adhered to the same service plan after they evaluated the parent. The department asserts that it was late. The sort of the raising of the issue by the mother's attorney was late. They were put on notice 18 months in the case. What's telling is the service she asked for was the very same service that their own psychiatric evaluation called for. There was nothing new. So if this court holds that this challenge was late, what it's essentially telling the department is that it can ignore the recommendations of its own professionals, that is now reasonable. And so in this case, not only, just as Viviana pointed out, the service plan was created late. It was 10 months into the case. I disagree with Mr. Ladd's statement that services only begin in a child welfare case after disposition. That's flat out incorrect. The Juvenile Code states that 30 days after a child is removed from a home, the department must develop a service plan. The statute also states that the department has an obligation of assessing the family and then designing a service plan looking at the family's individual needs. That was this court's ruling in In re Rude. In re Rude was sort of a manifesto on reasonable efforts, and this court talked at length about what that obligation entails. And at a minimum, it entails the department going out, figuring out what the needs of a family are, and designing a service plan accordingly. In this case, the department at the outset, it was Justice Young, your question to start the oral argument about did they know that she had a cognitive impairment. They absolutely knew, not just based on the evaluations, but based on both the trial court and the worker's assessment of this parent. And yet they chose to ignore it in the development of their service plan. And then the link to the termination decision, going to Justice Larson's question about whether this court has ever held that this could be a harmless error. It has not. And I think that this court's ruling in re Rude and in re Mason are clear on that. And Justice Young, it's your words that have been echoed at the Court of Appeals talking about the hole in the evidence, that a termination statute has both a past sort of looking component, but also a future looking sort of predictive component. Can the parent safely parent the child in the future? And Rude and Mason talk about reasonable efforts being a crucial component of that predictive component.
No, go ahead.
If the trial court had said, look, this wasn't a perfect plan, but it did provide enough, and I believe, notwithstanding, given her motivational problems, it's time to provide stability to the children, would that have been enough?
If the trial court determined, so it would depend on what the trial court found. If the trial court found that specialized services were offered to the parent and specified what they were.
No, the trial court looks at the whole record and says, look, was it a perfect plan? No, but I believe enough of the services that this mother needed were provided, and I find, as he actually did find, or she found, I don't remember who, that the mother's motivation was such, it was time to terminate so the children could have a permanent plan. Would that have been sufficient?
If the trial court found that the appropriate services were provided to this parent.
Enough of them. Not perfectly, but enough of them.
On this record, I don't think that would have been enough because I don't think the trial court could have made that finding. Because
so is that the whole here?
Excuse me?
Is that the whole? There was no finding in the court, and the trial court didn't make the finding.
I think the whole is that the trial court could not have made the finding. And to make such a finding, the trial court would have had to have ignored the evaluators who worked with this family.
Is the answer then to remand for a redetermination of whether the mother's plan was sufficient and let the trial court make that specific determination?
Well, I think the remedy here is to deny leave because that's what the Court of Appeals, that's what's going to happen.
I have trouble that the Court of Appeals was making stuff up in reaching its conclusion. If I reject their route to there, is there an alternative where we remand for the trial court to make an explicit determination about whether the services provided, whether perfect or not, were sufficient enough so that the plan
accommodated the mom's.
Scoured, yes.
Correct. I think that would be consistent with the Americans with Disabilities Act and the reasonable efforts requirement. That did the mother receive an individualized treatment plan that took into account need? But I think at the core of.
Do you agree that with Terry that a violation of the ADA is not a defense to termination?
I do. So I think that the logical step, and I think Mr. Restucci and I agree on this, is that the ADA informs the type of services that the department should offer, and then it's using this court's rulings in Root and Mason that if the government doesn't provide the services, then that creates the hole in the record.
So I'm trying to figure out what jurisprudentially significant thing I'm doing here in this case. And maybe you're going to say nothing, deny, and I'll go home. But because it sounds like we agree on a lot, or you guys agree on a lot. We haven't talked yet. But it sounds like you all agree that the ADA applies to the agency. The agency has to figure out what it means in a given case. And I can imagine that with some disabilities, it's easier than others, and this one might be harder. It sounds like you all agree that the ADA is not a defense to a termination. It's, the place where it shows up and does work is in the reasonable effort standard. The reasonable effort standard is going to somehow take account of whatever accommodations would have made it possible for the parent to succeed, right? And it's the one place you clearly disagree is just on whether there was sufficient evidence to support the judge's finding, even despite the lack of specific services. And that's not that jurisprudentially significant. But I understand your positions on that.
No, I agree. As Mr. Ratusha was sort of articulating the rule, when I think it was Justice Young asked what the rule should be, I leaned over to my co-counsel and said, that's our rule.
Yeah, that's what I thought.
Which is that if the department, and I wrote this down, if something is known to the agency, then that triggers a legal obligation on the part of the department to make a service plan that accommodates that need.
So the part that got me interested, and maybe this is bad because I shouldn't just get interested when something happens, was when I was talking to Mr. Ratusha about what the parent's lawyer's obligation is. And even Mr. Ratusha said it's not, the crappiest lawyer who doesn't notice that her client has a disability and therefore tries to account for it in this proceeding, that doesn't relieve the agency of its duty under the ADA to provide services that are sufficient.
That's
so
correct.
What work could that do? Is there something we can do about that? Is there any?
I don't think so, and I think the cases cited by Justice Young, Robertson, Pierce versus the District of Columbia, the ADA cases, talk about sort of the issue is whether the agency knows of the disability that needs to be addressed. Where does the parent's attorney come into play? When there is a situation where the agency has no reason to know that a parent has a disability, or no reason to know of a specific accommodation, then it's the obligation of the parent's attorney to make the agency know that. That's not this case.
Yeah.
Because at the outset of this case, everyone knew
that's clearly not
their own
this case.
evaluators. And so that would be the obligation of the parent attorney. You can't just sit back and wait and on appeal claim that my client was disabled when the record doesn't have any sign whatsoever that the client had a disability. What's challenging, though,
that's something we might have to figure out, but we probably can't figure it out in this particular case.
Correct. I think that's right. And what's challenging about a child welfare agency that makes it different than any other type of public agency is the affirmative obligation of a child welfare agency under the reasonable efforts prong to go out and find out stuff about a parent. Mm-hmm. Because even separate from the ADA, the juvenile code and federal requirements put a mandate on child welfare agencies to go figure out what's wrong with a parent and how can we address that. And so it becomes a little challenge. And the department in this case sort of did that. The whole in this case is that they got the information and then they didn't do anything based on that.
So I have one more question, which goes back to the conversation I was having with Mr. Ratusha, which is about some sort of a harmless error standard. I take it you resist that. You say we've never done it, but you also seem to say we shouldn't do it, and I guess I'm wondering why. Because, maybe there's some case in which if they had provided the services, it wouldn't have made a difference anyway. And here, there are kids involved. It's not like we can just, keep going forever. At some point, the proceedings have to end because there are kids involved. So why not a harmless error standard? I mean, it could be a harmless error standard that's very generous to the parent.
So I think the short answer is that the legislature in designing the reasonable efforts requirement didn't put in a futility or harmlessness standard in the language in our juvenile code. It lists, and just to sort of give the court perspective, there are other states that have included a futility exception to reasonable efforts, saying this is a parent who's so far beyond the pale that we can't rehabilitate, and we're going to let trial courts figure that out. Michigan hasn't done that. And so we have specific situations in which you can not make reasonable efforts. I think we all agree that this is not one of those cases. Right. And so this court would be reading into the statute a futility exception that doesn't exist. And the one case I would point this court to is it was an ICWA case, an Indian child welfare case, that was before this court, INRI JL, which this issue came up, whether the court should create a futility exception. And there it was dealing with the same type of active efforts, reasonable efforts issue. This court specifically rejected the request to looking at the plain language of the Indian Child Welfare Act. I would adopt the same sort of analysis. It's not in our statute. It would be creating something that doesn't exist.
Thank you.
All right,
Thank you,
very
Your
good.
Well, that one stuck. All right, case is submitted. People versus Demokowski. That is in Saudi.